Welcome to Chapter 12, everyone. This week we will be discussing FLSA, the Fair Labor Standards Act. FLSA governs overtime federally. However, some states also have wage and hour laws. If a state has both state and federal wage and hour laws, employees receive the more lucrative hourly amount. FLSA requires that overtime be paid to non-exempt employees when they work over 40 hours in any given work week. However, 3 states require that overtime be paid after 8 hours is worked in any one given day, even if there aren't more than 40 hours worked in the work week. Those states are Alaska, California, and Nevada. In California, if an employee works over 12 hours, any hours over 12 are paid at double time. Should an employee feel that they are owed compensation, they have up to 2 years from the date of work without compensation to file a claim with the Department of Labor. There are exceptions to the 2-year statute of limitations, but most employees have only 2 years to file their claim with the DOL. Employers must be careful when they provide non-exempt employees with a smartphone that allows the employee to answer and read emails at home. As a supervisor, if you notice hourly employees sending a lot of emails from home after hours, you need to ensure that you inform the employee that they should not be performing work while off the clock. You also need to ensure that you have a policy that specifically addresses non-approved work and hold the employee accountable with that policy. There may be a case where you may still be responsible for paying those wages, especially before the employee is given written documentation that they are in violation of the work policy. FLSA does not require breaks to be given to employees. However, some state wage laws do require breaks. California is such a state. If you are practicing HR, please ensure that you familiarize yourself with the state laws as well as the federal laws, and remember that the law that is most lucrative for the employee is the law that trumps. If employees receive piece rate bonuses based on workability or productivity, those bonuses must be figured into the overtime rate. You may take what they earn as a bonus for the week and divide it by the number of hours that they worked, add that to their base hourly rate, and that new rate is actually the rate that you will pay overtime for. By statutory definition, the term employ includes to suffer or permit to work. The work week ordinarily includes all time during which an employee is necessarily required to be at the employer's premises, on duty, or at a prescribed workplace. Workday, in general, means the period between the time on any particular day when such employee commences his or her principal activity, and the time on that day in which he or she ceases such principal activity or activities. The workday may therefore be longer than the employee's scheduled shift, hours, tour of duty, or production line time. Problems arise when employers fail to recognize and count certain hours worked as compensable hours. For example, an employee who remains at his or her desk while eating lunch and regularly answers the telephone and refers callers is working. This time must be counted and paid as compensable hours worked because the employee has not been completely relieved from duty. In fiscal 2008, the Labor Department awarded more than $123 million in back wages to nearly 183,000 employees for overtime claims. The top mistake for employers, and of course the most costly one, is wrongly labeling employees as exempt from overtime pay, according to the Labor Department. Certain executive, administrative, and professional employees are exempt from the Fair Labor Standards Act, meaning they aren't eligible for overtime pay. But the $64,000 question is, which employees qualify for this overtime exemption? Confusion over the revised FLSA regulations means that many employers, some estimates run as high as 40%, unknowingly violate the law. Technology companies in particular are being targeted by the Labor Department. The stakes are high. Employees misclassified as exempt can be eligible for 2 years worth of back wages. If the violation is willful, those employees can be eligible for 3 years of back wages, all payable at 1.5 times the hourly rate, plus liquidated damages equal to the unpaid wages. That means employees can collect up to 3 times their regular rate. How can you avoid becoming another victim of an employee lawsuit or charge statistic in the Labor Department? The key is to regularly audit your workforce classifications and job descriptions and ensure you're correctly classifying employees as exempt.